I'm happy to introduce the speakers of the first session of today, Transborder Commerce, Present Challenges. I would like to welcome Day Davis, who will speak about Brexit problems for IT lawyers. Day Davis is both a chartered engineer and a lawyer. He has master's degrees in both physics and computer sciences, but works full-time as a solicitor. Having been National Head of Intellectual Property Law and later National Head of Information Technology Law at avocats, Netherlands, Day is now a partner in his own solicitor's practice, Percy, Davis & Co. Day has consistently been recommended in the Legal 500s and Chambers Guides to the legal profession. As well as technology law and intellectual property law, Day also works in the area of high-tech product safety and security. I would also like to welcome Claire Benier, who will speak about GDPR liability related to IoT devices imported to the EU. She's a founding partner at ADSTO cybersecurity firm. She's highly experienced in civil, administrative, or criminal law, counseling, and litigation. She's recommended in all legal practitioners' guides in IP and IT, data protection, e-health, and cyber laws. She has been selected to join the Agora 41 since 2018. Claire publishes in various high selected reviews and gives lectures to the ongoing professional training of magistrates and lawyers. I would also like to welcome Françoise Gilbert, who is a partner at DataMinding in Palo Alto, who will speak about IoT and privacy in the US. Françoise Gilbert is one of the first lawyers to enter the field of data privacy and security in the late 1980s in the United States. She's widely recognized as a pioneer in the field of data law. She's the editor of Global Privacy and Security Law, a 6,000-page legal treatise that analyzes the data laws of over 70 countries on all continents. I would also like to welcome Bronwyn Furse, who's a partner at Thomson Geer, who will speak about data transfers in and out of China and other Asian countries. Bronwyn is a trusted advisor to a range of public and private sector clients on privacy and data protection matters. She has depth of experience advising on complex cross-border data sharing arrangements, data breaches, privacy compliance, and undertaking privacy compliance training and privacy impact assessments. Thank you very much for being here. And we are very much looking forward to your presentations. Before we kick it off, if you have any questions, please reach out via the chat function, and we will try to pick up the question either during the presentation or at the end of each presentation. Having said that, over to you, Day. Day, the stage is yours.
Good morning, ladies and gentlemen. I assume because Michaela is not waving her hands rapidly that you can actually see my screen and that I'm successfully sharing my slides with you. I have an awful lot to talk about, and I have given this talk on many occasions before, but not yet successfully in half an hour. So my aim is to get through as much as I possibly can in about 25 minutes, and then leave some time successfully at the end for some questions, which I hope there will be. So I'm going to talk very briefly about the Brexit agreements, and yes, that's not a mistake. It's agreements plural, not agreements singular, and I'll try and explain why some of the problems that we now have actually stem from the fact that we have more than one agreement. I'm going to talk very briefly about what's been known about the divergence between European and UK law for some time. That's been around for a while now. And then I'm going to talk about some specific topics for not too long on each topic: freedom of movement to software, database rights, GDPR. I know you've got some further GDPR talks today, so I won't talk too long on GDPR. Freedom of movement of hardware, because again, this is an IT-based talk, and then a little bit about dispute resolution, which is not, in fact, specific to IT. So let's start by talking about the Brexit agreement. And by the way, there's a couple of flags at the bottom of the screen. If anybody recognises the flag on the bottom right, not the Canadian one, but the other one, do send a message in the chat as to what that flag is. We'll be getting to that at the end of this particular slide. The first agreement that exists is the withdrawal agreement of the 24th of January 2020, and there was a lot of song and dance about this. It's very important about the fact that two things. First of all, it was a temporary agreement, by which I mean it said that it didn't actually deal with a lot of issues that were required in order for there to be a seamless transition, shall we say, particularly in the UK end, between, well, in the EU end as well, actually, between being in the EU and not in the EU. In other words, it was a partial agreement. And it's called an agreement because it was an attempt to ensure that Article 50 of the treaty was complied with, because the agreement, the withdrawal agreement, was classified internally by the European Commission, nobody's challenged this, as the agreement which was required under Article 50. That was quite important because it was required to be passed and approved formally by the European Parliament. And the European Parliament essentially had a veto under Article 50 of the manner in which the United Kingdom left the European Union. And that withdrawal agreement was eventually approved in end of April, if I remember correctly, by the European Parliament. But actually, it doesn't contain most or many of the issues and many of the transition provisions that were required. And those transition provisions are found in two other agreements. One was an agreement which also included Iceland, Liechtenstein, and Norway, so the EFTA countries, of the same 4 days later, and also, more particularly, the one which was signed just before the new year, but agreed just before Christmas last year, which is this Trade and Cooperation Agreement of the 25th of December 2020, the so-called TCA. Now, the first thing to say about the Trade and Cooperation Agreement, you can actually tell from the title. It is not a treaty in the same way as the European Union has a treaty with Canada, which is the Comprehensive Economic and Trade Agreement between the European Union and the member states. You'll see that the Trade and Cooperation Agreement is an agreement between the EU, and it's an agreement between the EU Commission and the UK. The Parliament has never formally approved it. The member states have never formally approved it. It's only the Commission that has agreed it on behalf of the member states. And that was because the last thing they wanted to do was to present the Trade and Cooperation Agreement to Parliament because they may not have got it passed, and particularly because there would have been difficulties in at least one member state where in the case of one member state, a particular sub-state of that state had said they wouldn't allow it to pass. That, of course, brings us to, did anybody get the answer to the flag right, Michaela? It brings us to the Walloons. Did anybody say Walloons, Michaela?
Unfortunately, I couldn't find an answer to it.
If anybody did work out that the flag is at the bottom right-hand corner is the Walloons, well done. Essentially, going back to the Canadian agreement, in Belgium, in order to approve the Comprehensive Economic and Trade Agreement with Canada, has to have the agreement of all 5 of its member states, in which one is Wallonia. And in essence, the Walloons refused to give assent to the Canadian agreement. There was a particular issue they took about it. Eventually, the Belgians and the European Union had to pay them off. I'm not quite sure how they paid them off, but they no doubt granted some political sop to the Wallonian Parliament in return for which the Walloons actually gave consent, but meanwhile holding the agreement up for 3 years. Three weeks. The Walloons said point blank that they wouldn't approve the UK leaving the EU formally. So in order to fiddle the books, shall we say, the EU didn't pass or didn't go down the route of a comprehensive agreement with member states, because they didn't want the Walloons to have a veto over the UK-EU, the full treaty, as it were, which is why we don't have a full treaty. And you might think that's a trivial point, but actually, as we'll see in a minute, when we look at data protection, it's actually a very important issue. The fact that there isn't a formal agreement, or at least in my view, it's a very important issue. The fact that they have fiddled this put it into a different box, the actual leaving agreement. But let's look at what's happened so far, because as I said, a lot of the law has already changed, in the sense that 60% of the law within the United Kingdom, certainly, and I suspect the same is true in other member states, is based upon European law. So the majority of our law, in terms of volume, is actually based on pan-European law. And of course, the interpretation of that, the ultimate interpretation of that, is the European Court of Justice. That is still true in the sense of that old cases that have formally been decided by the European Court of Justice, and indeed cases that are currently or were started before the 31st of December of last year, will continue to be ultimately determined by the Court of Justice and will have effect in English law. It is possible now in England for there to be divergence, and our superior courts, by which I mean the Court of Appeal and the High Court and the Supreme Court, rather, are able to overturn not follow European Court of Justice rulings. But in fact, there's a more significant issue, which is that we no longer, we being the United Kingdom in this context, we no longer have to follow European language versions. And if anybody's had any experience of having to look at different versions of legislation, whether they be directives or European directives or European regulations, you will know that the translations are sometimes good and sometimes not good. Believe it or not, the most common mistranslation is the word or. In other words, if A or B or C, then something happens, or if A and B and C. And you might think, how on earth can you mistranslate or into and? But actually, it's very easy, because the word or in the English language can either be inclusive or exclusive. In other words, it does have two meanings. And I have certainly seen pieces of legislation where that has been that word has been mistranslated. And other issues where there have been, you have to look at different foreign language versions to try and understand what it is that is being tried to be conveyed in the English language. And there are examples of that, indeed, in GDPR as well. Not many, but a couple. We currently have in Europe over 20 official languages. There are actually, anybody wants to ask me why, at the end we could deal with that. There are currently actually 23 and a half official languages. Yes, there is indeed a half official language. But of course, in the past, an English court has been bound by European law to look at all the official language versions, particularly if there's some ambiguity in a regulation such as the GDPR, which of course has direct effect. You have to look at the other instantiations to try and understand what it is that the court is trying, that the legislature, I should say, is trying to say. That's not going to happen in England anymore. I can't see an English judge ever being persuaded to look at a non-English version of a regulation in the future. So if you if you discard the other 22 language versions, essentially you've already lost a huge wodge of law, certainly in volume, because you don't have to look at the following language versions. And I say I can't believe that an English court would be very easily persuaded now to look at foreign language versions of legislation, whereas in the past that was a mandatory requirement of the European Union. I could also talk about other issues where the English court has departed, past tense has departed from the approach of the European Union, and we have different interpretations. Design rights being a good example, where in the essentially to summarize an awful lot of cases in the European court, design rights have been regarded as something which is, well, in the UK, certainly a design right has a life of its own, which in the European courts, the Europeans have tended to say that copyright and design rights are intertwined, shall we say, to a greater extent than English courts, which regard them as a completely separate right, and to a certain extent exclude copyright in items which are protected by design rights, whereas in Europe there is a greater tendency to allow copyright to designs which are a UK court wouldn't allow design rights to accrue to, because a UK court would say, well, if it doesn't fall within design rights, you can't try and create a design right out of copyright. That's not the approach of the European courts. But let's talk more about IT issues. And the first I want to talk about is the freedom of movement of software. The position about software is that, as you probably know, since the Adobe case, in fact, way before the Adobe case, it has been possible to retransfer software. So if a software licensor licenses Company X no longer wants to use that software, Company X can freely transfer that software to Company Y, irrespective of what the actual license may say, trying to prohibit such transfers. That's always been possible under the software legislation since 1994. It was tested in the Adobe case, but in fact it was perfectly permissible even before then. And this rule about transferability, otherwise known as exhaustion of rights. And in the UK, that is enacted in Copyright Patents and Design Act, and deals with the act of putting into circulation copies not previously put into circulation in the UK or EA. So you'll see that we've amended our law so that, provided the software was originally sold anywhere in the EEA, you can carry on transferring that software in the United Kingdom. This is a common point, or the next point is a common point, which is that virtually all European law has not changed. There has been no changes of legislation in Europe. There have been lots and lots and lots of changes in the UK to allow for Brexit. No changes whatsoever, and I mean virtually absolutely no changes whatsoever in European law. And herein lies the problem, or at least the asymmetry, shall we say, of the legislation. Because the legislation in Europe not having changed, the legislation carries on talking about programs or software licenses originally placed upon the market in the EEA, or originally placed within the European Economic Area. So what does that actually mean? What it means is that the existing rules continue to apply. And if you look at the underlying legislation in the Directive 2009, which is in fact a rehash, it doesn't change anything important at all of the original directive relating to software back in 93, which came into force in 94. The first said in the community, and for community you can read European Economic Area, have a copy of a programme, shall exhaust additional rights within the community of that copy. But of course the UK has now left that community. As I say, there have been no transition provisions. So what does the result of those no transition provisions mean? Well, if you look at the position before the 1st of January 2021, when we were still a part of the European community, that was the original agreement which essentially extended our membership until the 31st of December of last year. We were part of the community then, the United Kingdom was part of the community then. Any software put on the market, first placed upon the market prior to or on or prior to the 31st of December 2020 can continue to be transferred anywhere within the European Economic Area. However, that's not true in respect of software which was first placed onto the market, software licenses first placed onto the market on or after the 1st of January. If in that case, any software placed in the market within the European community, which was excludes the United Kingdom at that point in time, can only be circulated within the United Kingdom, within the European Economic Area. So we have an asymmetry, because what it means is that because we in the United Kingdom have changed our law to explicitly include the European Economic Area and explicitly include exhaustion of rights on a European, continue to have exhaustion of rights on a European-wide basis, we can import into the United Kingdom software first placed on the market whenever it was first placed on the market in Europe, whereas in Europe, you can freely transfer software, and you could freely transfer software first placed on the market in the UK, but only software first placed on the market on or before the 31st of December last year. So as time goes on, there will be a growing body of software first placed on the market in the UK, which can no longer be freely circulated in the UK. And that is, I'm dealing specifically with IT issues in this talk, but the basis of what I've said is in fact true for many pan-European exhaustion of rights. And it's all based upon the fact that there were no transition provisions, no continuing change at all to European Union legislation. It was just left as it is. So let me talk a little bit about database rights. And database rights are a little bit more complicated and go back to this issue of what are the actual agreements, why we have 3 agreements, and what do the actual agreements say? Let me just remind you about one of the criteria of having a database right, which is the basis of the issue that I want to talk about. And that issue, or that requirement, is ownership. And what it says is that it applies where the makers or right holders are nationals of a member state or who have their habitual residence in the territory of the community. That's Article 11 of the direct underlying directive. Notice the word are and notice the word have. Those are present tense. Now, I told you that different legislation translations sometimes say different things. Well, I've checked the Spanish, I've checked the French, I've checked German, I've checked the Italian versions of the legislation, And I've also checked the actual instantiations in those countries. They all use the present tense. In order to have a database right in the European Union, you have to be present tense a national as the owner. We have to be a European company. The legislation that deals with the database rights is the ADSTO agreement, believe it or not, this third agreement, the second agreement rather I listed. And what that essentially says is that it maintained complete neutrality until December 2020. In other words, we continue to be treated as a European Union. The United Kingdom was continued to be a member of the European Union for database right purposes until 31st of December 2020. What is the position after that? Well, Article 58(1) of that treaty says that EU holder of a UK right prior to the 1st of January shall maintain enforceable right. Well, that's fine about past database rights. But what about future databases created by UK citizens? What it says is UK nationals shall be deemed to comply with the requirements of Article 11, Article 11 being the one about being right holders. So we have a situation where this agreement, in fact, it's the agreement with the ADSTO countries as well, says that UK citizens are deemed to comply with the requirements. This is where it gets interesting, because you think to yourself, what does the actual Spanish law say? What does the underlying French law say? The underlying German law say? I say I've looked at those underlying laws, they haven't changed. Say that there were no transition, there was no legislative changes put into place by the European Union, only one-way changes that we had, and we had millions of words about the changes and extending the rights to European Union, but nothing the other way around. So what this means is that you have a treaty, not signed by member states, signed by the European Commission, saying that, oh yes, it doesn't matter, UK citizens are okay, but you have underlying law in countries like France, Spain, Italy, etc., which say, no, you've got to present tense be a national, which obviously the United Kingdom citizens in United Kingdom's countries no longer are. Now, it's interesting, you look at the textbooks, and the textbooks all blithely say that the European Commission can do such things. The European Commission can essentially bind member states by statements such as this. The interesting thing is that when you look at the case law on which those statements in the textbooks are bound, you'll see that actually the cases don't match what they're alleged to have said. There has never been a case in the European Court precisely on this point. Can the European Commission, in this singular way, overrule national law? I say that not because I don't believe that if this matter ever went to the European Court of Justice, the European Court of Justice wouldn't try a way to try and give force to what the European Commission had agreed. I say this only because it throws doubt on what could have been a very clear amendment to legislation, which we don't have. You know, we could have had a statement, as in Article 58(1), that they shall maintain enforceable right, but the European Community hasn't done that. The European Commission, for whatever reason, didn't want to agree that. So there is doubt in terms of UK database rights, where's the words in the past. Of course, what all that means for you as Europeans is to make sure that your UK subsidiary doesn't own the database right, but rather the database right is owned by a company which is in Europe. But for us UK citizens, it's the other way around. If we want to be absolutely certain, don't allow a UK company to own a database right, assign the right to a European company. A similar sort of point, but a very quick point about GDPRs, saying I know they're going to be, yeah, I'll leave the comment about metrification. That's not really, it's not really highly relevant. Let me move on instead to talk about, talk about GDPR. No, apologies, GDPR. We had 82 pages relating to data protection in the primary treaty, the TCA, the so-called Trading Cooperation Agreement, the one that was signed just before Christmas. 82 pages relating to data protection. You might think, therefore, that data protection is very well covered within the legislation, but actually the contrary is true, because there's only 2 pages of that 82 pages related to GDPR. Most of the other 80 pages are all about essentially the UK and the EU continuing to exchange criminal-related data and databases relating to government. I will put the metrification comment in. When we check, there is a talk in the UK now, by the way, of changing back to pounds and measuring weights in pounds and things like that. But when we had metrification in the UK, which was a European Union requirement, the metrification was done in such a way that all us poor citizens had to metrify, and we weren't allowed to sell tomatoes by the pound, we had to sell tomatoes by the kilogram. And we had to express things in metric and not in the old weights and other systems, pre-metrification systems we used to use. What actually happened, of course, was that the government couldn't afford to metrify itself. So we have this ridiculous system in the UK where everything that individual citizens do has to be done in metric, but everything that the government does, like road signs, continues to be in miles, not kilometers, because it was too expensive to the government to metrify. So the land registry, for example, still measures things in acres and hectares. And it's a little bit the same about GDPR. So 80 pages relating to intra-government exchanges of data post-Europe, 2 pages relating to what poor old citizens like you and I have to do about GDPR. And it was a very last-minute agreement about GDPR as well. You could tell that from the fact that they didn't even have the time to change the numbering system, and it's the only section which is an A, in this case F10A, in financial provisions. They had to shoehorn it in somewhere. Essentially, what it says is what you know, that the UK was given a continuing data protection provision to exchange data with GDPR, provided that we were granted an adequacy decision, which we were before 2 days before the deadline, 3 days before the deadline. At the end of June, we were given an adequacy decision. So UK and EU, for the moment, review in 5 years' time, are continued adequate, and you can exchange data freely with the UK, with one slight difference, which is that, of course, the UK is no longer part of the EU. So that if you are a UK company and you have you are complying with GDPR, you actually have 2 GDPRs to comply with. And indeed, as European Union citizen companies, you have 2 GDPR to comply with, one a European pan-wide GDPR and the other a UK GDPR. And because the designated representatives definition was never changed within the European Union, and therefore a UK citizen is not within the European Union for the purposes of GDPR, what that means is that if you are a UK company with a UK database, and you process data about European Union citizens as well as UK citizens, then in respect of your European Union citizens, you need a designated representative within the European Union, i.e. not in the UK. So you need essentially a data control in the UK needs to appoint a designated representative somewhere in the European Union. I appreciate that my time is very nearly up, so I'm going to talk very, very quickly about freedom of movement of goods and very, very quickly about law and jurisdiction, and then hopefully there might be some time for questions. Freedom of movement of goods, of course, we're talking about IT hardware as much as anything else here. IT hardware is subject to this mark at the bottom right corner, CE marking, to give it its correct name, which is essentially sometimes regarded as a European-wide safety mark. It's not actually a safety mark. It's essentially it is partly a safety mark, but it's primarily to do with the freedom of goods and essentially a requirement that goods are built to the appropriate standards. And there is a very close intertwining between the legislation and standards in this area. And that's, as Michaela said, one of the super specialisms that I sometimes practice in. The requirement now is very complex. In the past, we had one legislative provisions and indeed one set of standards that applied throughout the whole of Europe, and you had European Union-wide standards that were the primary determinant of whether goods could move around Europe. Now we have three regimes where there was one regime before, because we have the CE marking regime, which continues to apply in Europe. We have the UK CA mark, which is the equivalent in not the United Kingdom. So despite the fact it's called the UK CA mark, it only applies in Great Britain, not the United Kingdom. What's the difference in Great Britain and the United Kingdom, you say? Well, Great Britain is Scotland, England, and Wales. The United Kingdom is Scotland, England, Wales, and Northern Ireland. So Northern Ireland, if you have something which marked with the UK CA mark, you can't import and export your goods into there. That has to have a UK NI mark or a CE marking. This is all to do with the Northern Ireland Protocol, which I could talk for a long time about, but suffice to say that you can't have, there are three different regimes, and if you mark goods in Northern Ireland, you have a choice, but you don't have a choice in the UK. You mark in the UK with the UK GB, I should say. You have to mark in the UK CA. And the CE marking, we don't accept CE marked goods anymore, and vice versa, you don't accept UK CA marking. This is quite unusual because most of the countries in the world, even America, has agreements with the European Union to reduce the amount of double testing that you have to do, for example, between Canada or Australia in terms of goods which are imported and exported. We don't have that, was never agreed as part of the deal. So essentially we have three different regimes. So what it means in practice is, whereas in the past you could freely move your IT hardware if you're a company with subsidiaries throughout Europe, you could happily move bits of server and hardware between the UK and the rest of Europe. You can no longer freely move those servers between the UK and Europe, and you have to look at the different requirements now. At the moment, there are very few different requirements because we haven't adopted yet different standards than the EU, but that is happening as we speak. The standards will slowly diverge and the differences will become more important. So last 2 minutes, not even that, on law and jurisdiction. In fact, I'm going to talk about, well, there are three issues. What's the governing law of a contract? What's the jurisdiction in which you're going to enforce the decision, or to get a decision, and how you're going to enforce it. Service these days is also, it used to be an issue, but it's no longer an issue, certainly in the UK, where we allow service by internet, by webmail, emails. Service is usually accepted in the UK these days, but it can be an issue in some countries. Governing law is dealt with by the Rome Convention, which is a name given to the appropriate European Union regulation. We are no longer, the UK is no longer part of regulation, that regulation, because we've left Europe. However, we have a law in the UK which essentially reflects the Rome Convention. In any event, the Rome Convention allows freedom of choice in many, many cases. Intellectual property disputes, patent disputes can only be determined in the country in which the patent resides, but with those exceptions, most contracts, most of the time, freedom of choice, and that simply continues. And it doesn't matter under the Rome Convention whether the freedom of choice is given to a European Union country or a non-European Union country. So it doesn't matter anyway. There's no change essentially for the question of governing law. Jurisdiction is a different matter because jurisdiction is dealt with by Brussels regulation and is limited to the European Union. It was extended to the EFTA countries by what's called the Lugano Convention. And it allows for exclusive or non-exclusive jurisdictions. The UK applied to join the Lugano Convention and has been given the boot by the European Commission, who has said, no, we won't let you join the Lugano Convention. This is all political football. There's no logical reason why the UK can't join the Lugano Convention, other than the fact that the European Commission want to extract whatever they want to extract from us in return, and we won't give it, we being the UK. The result of that is that the UK is no longer part of that convention. And this is an important point for European companies as well as UK companies, which is that if you put the exclusive or non-exclusive jurisdiction, that you can't rely on the Brussels regulation to enforce it. The backstop, there are in fact two backstops. One is the Hague Convention. Now the Hague Convention is an international convention, but about 70 countries in the world, including all the European Union countries, are members of the Hague Convention. But that only gives enforcement to exclusive jurisdiction. So the bottom line is that if you have an agreement with a UK company and it gives the non-exclusive jurisdiction of the court of X, you can't rely on the enforcement of that, and you can have an argument about that post facto. Whereas if it says exclusive jurisdiction, it still works because it works under the Hague Convention. So I've been busily changing all my non-exclusive agreements to exclusive jurisdiction clauses. There is another way around it, which is to do with mandatory arbitration under the New York Convention, but I won't deal with that because I appreciate that my time is up. So I don't know if I have any time for questions, Michaela, but if there are, happy to answer them. Otherwise, it's the next speaker.
Thank you very much, Dave. This was very, very interesting. Yeah, we received a few comments in the chat. Maybe just in the interest of time, one quick question. Not sure whether it's easy to answer it quickly. One question is that, yeah, there were a lot of problems mentioned with regard to the treaties not stipulating things. Do you think that there is some way or a possible solution in this regard?
So a problem, people waiting, did you say? People, I didn't hear the question properly.
The question in the chat is, do you think that there is in some way a possible solution?
I'm just looking through the chat to find the question. Which question is it in the? Is it in the Q&A or is it in the?
Yes, it's in the Q&A.
It's in the Q&A. Regarding recognition, was that first one?
No, that's a comment. So I think it referred to where we talked you talked about the database rights and the issue that it's basically not.
Okay. Yeah. Oh, I've got the question now. This is true. The textbooks can't be right. It's very confusing if you look at underlying legislation, and if you look at you can look at your own country, Spain, France, wherever afterwards, and you'll see that it's very clear in your instantiation of the legislation that you have to be present tense a UK company or a UK citizen. And of course, that doesn't include the UK. And then you say, well, the only way around that is if this statement by the European Commission overrules it. And there has been cases relating to whether or not the European Commission can arbitrarily determine pan-European law but nothing as blunt, as completely blunt as, by which I mean the European Union Commission is saying one thing and national law is saying the complete opposite. Nothing as blunt as that. The cases that there have been one or two cases, have been really strange cases, but they haven't involved anything as obvious a difference as that. And the real issue is not so much will the European Court actually refuse to give credence to the European Commission's requirements, but why is there any doubt anyway? There shouldn't have been any doubt left in these treaties at all. It should have been absolutely crystal clear, and it's not clear. It's the best thing you can say. And you know, my view is that somebody at some point in time is going to have a big argument about a valuable database, right? And why should they have to have had that argument?
Okay, thank you very much, Day. I will now hand over to Claire Bernier. As previously mentioned, she's an expert in IP, IT, data protection, cyber laws, and she will speak about GDPR liability related to IoT devices imported in the EU. So over to you, Claire.
Thank you very much. I hope you hear me. Day, could you stop sharing your screen so I can share mine? Thank you. Is it okay with you? Can you read? Can you see everything? Okay, super. So yes, I'm going to talk about IoT devices imported to the EU. But first of all, I would like to present the issue about IoT. So the first thing is what is an IoT concretely in real? So the thing is, it's filling with different things. You've got cloud computing, machine learning, artificial intelligence, and all that together, it is an Internet of Things. So you could see that it's covered many things. The other thing is the IoT is definitely something that we are getting into on an everyday life basis. It's definitely encouraging technologies. The more you've got IoT, the more you're going to get IoT. So if you see now the actual situation of the data, how much data are we exchanging, producing per day? It's 167,000 times more than what the US Congress Library's data is containing. So this is a huge situation. Also, how many IoT do we have? So remember, 10 years ago, there was almost none. Now we've got 7 billion, and the experts are considering that in 2025 will be up to 22 billion. When we talk about IoT, we talk about the data behind. We talk about how life is impacted by using IoT. So, okay, what does it mean? But what is it for? Is it good? Is it bad? Does it help? So we can see that for the economy, yes, of course, this is good because you create a need for people, and you see that it's starting to be a real market. IoT is definitely something incredibly economically interesting for everybody on every single market. Then for the humanity, we will see later on, from I would say, a more generous and philanthropic side, you could see, yes, this is improving a lot of knowledge. The IoT is helping, hopefully, the people to be better or to improve their knowledge about plenty of things that it's very important for the humanity, like on energy. We're talking about ecology, energy economy, saving for health situation as well. So definitely we've got a positive also for humanity. And this is because we are lawyers. So I wanted to say a little bit about law. yes, this could be a very interesting source of data and information and evidence for justice. We've seen several times IoT information being taken into account by judicial court for as evidence, and we're knowing that this is going to be more and more that way. For example, having an accident and showing that the accident has killed, for example, your sleep. So you had an IoT, you had a watch who was recording your sleep before. You could show that and say, since my accident, look, I can't sleep anymore. And this could be accepted by justice as an evidence. Is not the evidence, is as an hint of yes, something happened. The next question is, who is really benefiting it? So we've seen that, of course, the economy in general, the humanity in general, but we could see that we've got a lot of things that is on different market, as I said. So for the health, we've got now connected watch, connected scale, connected toothbrush. We know that we are improving the health. We are improving a lot of things. We are helping people to improve themselves, to take care about themselves. And so this is definitely positive. We've got also another very important and market becoming more and more important, which is the actual security on driving, transportation. We've got connected camera, we've got connected windscreen with augmented reality, and we've got Bluetooth tracker. All of that, we've seen that it has changed the way of people were considering their cars. We are looking now for cars safer, having a driving assistance. This definitely is something important. In France, we had just a law passed about the safety of the road. And so now when you've got a connected camera and any other IoT in the car, which is recording data, this is going through a specific services, we'll see later. And so this is definitely helping to improve the infrastructure of the roads, to improve everything that could make the driving safer. And then the final one is the actual improvement of the body itself, the person itself. We've seen connected jacket now for runners, connected t-shirts. We also have, for those who are dancer, we have connected dancer point shoes, who is definitely describing the position. And so it's helping dancer to improve their actual position, the movement. So this is interesting to see that, because so far we could see that the IoT is definitely something positive for the user. And we understand more that the actual explosion of the look for, the need for users to buy IoT. So now starting a little bit on the real subject, which is the GDPR. GDPR means data spreading. So IoT and data spreading is quite interesting, because you've got different people, definitely, that are interested of the personal data. Of course, you've got the user itself. He is free to give this data to anyone. So that's why you've got, question mark on this. Then you've got the government. We've seen that a lot with the COVID, this crisis, the sanitary crisis, where a lot of IoT was connected. Application, where do we, for the contact person, so you know that it has been in our lives for the past 2 years almost. So we've got the personal data who is gone to the government. Normally this is controlled by the Government Information Service, and they can give it to the service providers, and the other way around. The service providers can go back up. For example, when you register your pass in a bar or whatever, then it goes back to the Government Information Service, then it goes back to all the connection, and then we know if you have been in contact with someone who's got like the COVID or not. And then what is more for us, it's not problematic, but it's where the issues most of the time are, is we put manufacturer, but you've got to be careful because there's two situations. You've got the manufacturer and you've got also the data processor, the data controller, because you can buy something, but the manufacturer can sell you something, but being not in charge of the actual management of the data that the IoT will contain and would collect. So we put manufacturer, but it could be also data processor. We simplify the slide. And so we've got a lot of people that could be interested with this data. We've got the concessionaries database, of course. We've got more and more the insurer. That is something that you will see. We've got more and more insurance on that. And right now in France, I'm talking about France because I haven't looked around if that's something similar in other countries. But in France, if you're a young driver and you accept a camera in your car, you pay less your insurance than if you were not accepting your camera. Because in France, unfortunately, but I suppose it's similar to any other country, young people are less good drivers than a little bit older people. So the insurance are saying, okay, we want to make sure that you know how to drive. And so if you accept the camera, we will know if you're, responsible for the little accident or not. And so we will be having a better approach of the situation. As I said, you've got the road safety education centers. That's also important because we can focus more when we try to learn to people how to drive, when we know which situations are accident causes or are accident creating a possible accident. It's better, we can prepare them better. And so when they will take the driving license, we will put them in situation, the hardest situation, the one where they're the most accident, and so they will be more prepared. So probably we will decrease the number of accidents in this situation. And of course, all the service providers and all the publicity commercial providers. So that's something, again, that is interesting to see. Then we've got the privacy paradox, which is very interesting. You've got more and more IoT. You've got people that are more and more interested to have IoT. You've got more and more people buying IoT. Most of them consider that the security of the data is not taken into account by the IoT manufacturer. 77% of the population are defiant about their usage of their data. So in one way, they are more defiant in IoT. In one way, they consider that data are less protective. And then on the other side, they keep buying it. So this is a human paradox, I will say. It's a little bit French, I think, in some ways. And so the explanation for that is that for the people, seeing their data make them more real. They consider that, yes, we are more aware of the fact that we are giving away data. But we prefer, in any case, having the service instead of not having the service and protecting our data. Especially that is starting to be in question about the health data, as you will see later on. Then after, when we ask people, what do you think about what will be the risk, the cyber attacks? What are they the most the most interesting for you, or what are you fearing the most? Cyber attacks about their data is really the 4th and 5th in the top 10 risk that the people are considering like that. So it's quite interesting to see this paradox, because we are aware this is, we are giving a lot of very sensitive data. We are aware that the security is not completely secure about that. We are aware and we are fearing cyber attacks on these, but still we buy it. So now getting onto the GDPR. GDPR is having, personal data and concern. And so before getting onto IoT and GDPR, it is interesting to see few types of data, and you will see that almost all IoTs, in fact, are personal data. So of course, you've got the health data that are definitely personal data, considered as sensitive data with the CNIL group, health working group. So this is, European as well. You've got for the fashion, for the clothes, but also for your house. When you put the energy on, when you put the light on, this could be considered as a habit. The use of things that could be genetic, biometric, and comportment, behavior data are also there. And this is personal data, and this is sensitive data. And then you've got the vehicle, and in this situation, we consider as well that it's personal data. So clearly, on IoT, almost all data are considered personal data. Here's the situation, and that's really the liability. I'm running a little bit fast in the slide because I don't want to spend too much time and give less time for the next speaker. So liability on the GDPR. We considered different situation. You've got the actual manufacturer of the IoT. Then you've got the real data controller of the IoT, the person who will be, well, the company who will be really collecting the data, giving the data, using the data to the user or to others, and then the user. And you could see that almost all situations, the GDPR will apply. The only two situations where it will not apply is that the manufacturer is outside, is in the EU, the manufacturer, but the actual data controller and the user are outside the EU. And so the manufacturer don't get any data. This is just the hardware, is just sending the over, and is not doing anything else, and that's it. And the other situation is when the manufacturer is out the EU, the data controller is out the EU, and the user is out the EU, and there's no GDPR applying. On all the other situation, definitely the GDPR will apply. And so you will have to, as I say, you will have to, follow all the rules that the GDPR is actually imposing. So what are the risks if you're not respecting the GDPR? As you know, I think everybody knows that you've got a problem about the breach and what are the penalties. You see, we were wondering whether the actual companies were the actual authorities were going to apply at some point fines that are allowed by the GDPR. Well, in the year 2021, you could see we just take up 3 decisions, and you could see that the amount are quite heavy, especially the last one that is just happened a few days ago. The other thing that you got to remember is the actual liability. And so who will be liable? Who will be responsible for what you're doing? And on this, we focus on the health IoT. The connected device, when the connected device is considered as a medical device, in France and for the World Health Organization, monitoring and connected device relating to health are medical device. So not only they are submitted to the medical device legislation, but also, of course, to the GDPR relating to medical data. The thing about it is, imagine, we could consider, and we are getting onto liability, you could consider that the IoT could give information, kind of not diagnosis, but could be used to help to make a diagnosis. Who will be responsible if the actual IoT is giving partial information, not full information, or the data are okay, but actually the diagnosis is wrong? So far, we could consider that the actual doctor could be responsible for this error in the diagnosis. However, what will happen if the actual device is defective? Would the manufacturer responsible because of defective devices liability? So would the doctor say, it's not my fault, it's the fault of the device? The device will say, well, okay, we are a medical device, but we are not really a medical device. That's something that might be in the future, something questionable, and we will have to keep an eye on that. Then, of course, you've got all the other liabilities. For the moment, we've got the national laws, the customer law, the defective devices, possibly the custody of the thing, the criminal law, the corporate social liability, you know, all that. But what about the future? We know that a lot of situation or some people are considering that the robot should have a liability. Well, the IoT should have a liability. We've got the Delvaux report in 2017. We're saying, well, we need to question these. What, you know, what about proper liability for the robot? This is question, you know, this is again something that we have to look for. It has been the years since we talk about robot liability, IoT liability. I'm not quite sure to see where we hand, because at the end of the day, it's the manufacturer, the data processor, data controller, or the user that will be, I would say, in jail, behind the bars. So this is something that is, we need to keep an eye, although in the last years, I think this is decreases. The interest for such liability on the actual technical tool is not anymore really you know, a very important issue. Then this is something that I wanted to raise your attention about. This is quite interesting for us. This is a decision on Health Data Hub. This is typically French. This is a French Administrative Supreme Court that take this decision on October 2020. So you've got to remember that with the sanitary crisis, we had a lot of data. The French government start up an application with a lot of health information about French citizens. So it's collecting a lot of tools. So Health Data Hub is collecting a lot of tool, and the CNIL, when well, to store all this information, Microsoft was actually selected to do that, to store all the information. However, the CNIL said we don't want Microsoft to get these for different reasons. We summarize that. We say no, we don't think that this is safe, and so we are not allowing the storage of this health data to Microsoft. And for the first time, we had a decision of the French Administrative Supreme Court who said, well, actually, there has been a little thing at the end of the contract with Microsoft Ireland. And in fact, Microsoft Ireland are committed not to process data stored out of Europe without taking care or without considering the whole situation of what Microsoft will be submit to under its own law as a US company, held US company. So this, the French Supreme Court, the French Administrative Supreme Court said, okay, we allowed Microsoft Ireland, we confirmed that Microsoft Ireland can store the data for the French citizen. And, but it added, well, actually, okay, it can store, but we asked the CNIL to check, the CNIL being the data, the French data agency authority, check on, checking the whole thing about the personal data. And he said, well, I would like the CNIL to actually check that everything is fine. Well, the thing is, the CNIL said a few months ago that it was not allowing this. It was not fulfilling the right situation, and it was not possible to do that. And so we are in a bit of a strange situation where in one side, you've got the French Administrative Court, which said yes, but we asked the data authority, which consider that it's a no, to check that it's a yes. This is, again, I would say, typically French, because this is impossible for the CNIL to take position on that. He can't say no and he can't say yes. So again, this is interesting to see that. And all that is this IoT storage. Finally, I'm going to do, my slide will be available. So this is okay for impact assessment. will explain to you in these that if you have to do an impact assessment, you need to have these 2 criteria, or you have to have only one, but your process seems highly risky, and there you've got to do your checking. And then finally, we just put some practical guidelines, but as your lawyers, you should keep that on mind. But you know that when you're talking to your client who are manufacturing IoT, or will be the one that are controlling the IoT data, you've got to be very careful that the users are fully aware of what data you are collecting, what person will be will receive the data, how is how long will this data will be kept, and etc. 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 Here it is. I've slightly been over time, but not too much. If you've got any question, please do not hesitate to ask. And the presentation will be available on the IFCLA website, I think. And I hand it over to Françoise, I believe, or to Michaela first.
Thank you very much, Claire. Yes, I would directly hand over to Françoise. As mentioned, she's an expert in privacy and security law, and I hand over to Palo Alto, where it must be actually very, very late or early in the morning. So over to you, Françoise.
Thank you, Michaela. I need Claire to remove her PowerPoint so that I can send mine, I guess. Claire?
Yes, sorry. I'm looking for the, okay, the little button, sorry.
Okay, so let's see whether it works. Super. Okay, so thank you, Michaela, for your introduction, and thanks also to Belen and the IFCLA for the invitation to speak today. I'm going to talk again about the Internet of Things, and for me the Internet of Things is an internet of really many things. It's interesting, the figures that that Claire had are different from mine. What I have is that we already have 25 billion connected devices. Maybe it's the US that is bringing a heavier amount of devices, and we should get to 25 billion by 75. So the way I look at the Internet of Things is actually looking at the applications and where it is used. So there is, of course, the consumer IoT, which that we can touch almost here, our smartphones and so on. But there are also other applications of IoT, commercial IoT, industrial IoT, infrastructure IoT. Excuse me, and even military IoT that are tremendously important and that have implications that I think that we need to be aware of. So consumer IoT, you have all of those devices, wearables, children's toys, smart speakers, and so on. We are all familiar with that. And on the industrial and commercial IoT, I put the IoT applications that are used, for example, to optimize the performance of equipment, and for shelving and storage management. For example, a number of our clients that are, excuse me, that are large supermarket operate their storage and their collection of goods using IoT devices and IoT applications. We have smart buildings. When you have your card, a card that looks like a credit card that you use to get in and out of the building. And I have a case about that I'll tell you about. We have agricultural crop management. That is also performed through IoT devices and applications. Also the government applications. My favorite is smart cities. I love the magic of standing at the bus stop and knowing exactly at what time the bus will arrive. Well, that's IoT. There is a bus that is communicating with the bus shelter. It's wonderful, and but it's used also with tollway payment systems, sensors that are used to monitor traffic, smart lighting, surveillance cameras, watering systems, and so on. So a number of applications that also connect one way or another with very important sensitive data. So IoT is a landmine, and we have security issues, we have privacy issues, we have legal issues. But it's the legal background, and I don't think I'll have time for that. We have the consequences and all the contracts that are there to structure and think about acquisitions of company. Company A acquires company B, and now acquires all the liabilities and the defects of the products that the acquired company has created. How do you deal with that? Commercial contracts also. How do you deal with your subcontractors, service providers, those who provide the chips and so on? And here again, you have to think about the consequences of these devices. And of course, as Claire mentioned, the ethical issues that are looming with more IoT and more AI. You combine the two, and you could get into very slippery situations. So let's talk about the security first. And security, we all know about security by design, and that's what we lawyers tell our clients. I'm sorry, that's we tell our clients, but do our clients do that? I'm not sure. And one of the problems with many IoT devices, in particular in the consumer area, is the very low cost of these devices. And low cost of the device in the consumer's hand means very low cost of manufacturing, designing, upgrading, servicing, and so on. And that's where we see an increasing amount of flaws. And of course, not to mention the new trends of ransomware attacks that also could have very significant consequences. And ransomware is where the money is. So we see more and more of that. So some examples of security incidents that we've seen in the past 10 years or so with the excitement of all of these devices. And at some point we had a trend that we used to call the nanny cam cases. A lot of people bought these cameras to put in their homes to watch the baby, to watch the dog, to watch the door, to see who is delivering the Amazon package and who is stealing the package. Well, unfortunately, these devices have had a lot of security problems. And for example, in the TrendNet case, that was security camera, and there were security deficiencies such that in the end, the hacker was able to post the link to the live feeds in the home of people. And so that went to such an extent that it reached the FTC's attention. On the other one, on the right side, ASUS Tech, that's another type of invasion of people's information. That there was a USB drive that you could put in your computer, and then you would create your own cloud and store all of your information. And of course, guess what? There was a security problem, and all the information was spilled and posted on the available on the internet. So these are these are real, real incidents and real concern. One of the most recent was Zoom, this wonderful technology that we are using today to communicate with you. Zoom is a California company built almost in my backyard, and in July 2019 it had 300,000 paid customers. Now fast forward 10 months and COVID, and we go from 300,000 to 300 million. And so, well, there were a number of security incidents that caused the company to have visits from the Federal Trade Commission. But there is also a little bit of an explanation when you have this kind of raise in the number of customers, glitches have to happen. So of course, Zoom had to go through the usual FTC investigation, and the final order was published in February 2021. It's a very good summary of the typical FTC case. So if you're interested in seeing all of the bad things that can happen to a company that faces the FTC, Zoom is a good case. I'll provide a link to that. The typical verdict is having to recreate a complete security program to delete the data that have been acquired and make sure that you have proper data deletion policies. One thing that's very expensive is that the company gets a 20-year relationship with the Federal Trade Commission. So we should all, here's my commercial for Zoom. We can use Zoom because FTC is watching and watching what kind of security measures they have in effect. The company has to file annual or biannual reports of their security systems. And the CEO has to make a personal certification that everything is working. A typical FTC order, but that's the best way to explain to your clients what happens when they don't do what they're supposed to do. So facing this wave of security incidents, we have seen a very strong reaction from the government in every aspect of the government. So the FTC has been very active, and it's in my experience, I've never seen the FTC focusing so much on so many IoT cases. The FTC tends to look at cases, they want one of these and one of that and one of that, so that they cover the whole range of cases. But for IoT, they are more than just one each. And it has published number of reports and guidelines and so on, which are very useful, and I again provide the links. But that's not enough. On the legislative level, we've seen federal laws being passed. Internet of Things Cybersecurity Act of 2020. That's mostly directed to the protection of IoT used by government agencies. And then more recently, we've seen again, reports, guidelines, orders, executive orders published, White House, Department of Homeland Security, NIST, which is the equivalent of in ESA in the US, it provides standards. So what do these laws say? Well, the federal law, again, Internet of Things Cybersecurity Act of 2020 requires the implementation of security standards and the adoption of vulnerability disclosures among the different service providers to the government, so that they can since they rely on each other and they combine their solutions, they should be aware of what's going on within each of the companies. Executive order by President Biden came up May 12, 2021. Same thing, requiring standards, standard playbook for responding to cyber incidents and the like. For DHS, this one is interesting just because it raises the problem I was mentioning earlier, that this security directive from the Department of Homeland Security followed a ransomware attack on pipelines. And that shows, or that reminds us of the importance of the use of these IoT devices when they deal with critical infrastructure. And so that's the reaction from the Department of Homeland Services. Okay, so that was federal. Now, what do the states do? And of course, California has its own. California IoT security law passed about 3 years ago. And it's not a huge law. Basically, what it says is, hey guys, if you sell IoT devices, I want you to have reasonable security features. And one of those is make sure that the password is not 1111. I mean, it's crazy to think that you need a law to tell people, make sure that each user of different devices has its own password, but that's life. Same thing for Oregon, basically the same law, the same concept. Equip your devices with reasonable security measures and make sure that the pre-programmed password is unique to each device, or find a way to allow the users to create their own password. That helps in litigation, because we see a large number of cases. One thing you should not forget also, the US, it's great to have GDPR. You have one law and everything is in there. In the US, we have 1,000 laws. And so you need to think about a lot of different situations. And security breach disclosure laws. So you have your internet device, there is something that goes wrong, you lose your data, you need to report to the data protection, not the data protection authority, sorry, the local attorney general, which is kind of the equivalent of the data protection authority for you. And of course, there are 50 states, therefore there are 50 laws, and they don't all say the same thing. So that makes a lot of lawyers happy. But going back to the IoT, you have to think about those security breach disclosure laws, because your device or your application could be covered by that. And on top of that, not only do we have state security breach disclosure laws, but we also have federal laws like that, in particular in the healthcare area. And as you know, a lot of the IoT devices are used for health purposes. And guess what? We have a law for that. Disclosure requirements, security breach disclosure requirement that apply really for those situations. The legislation for healthcare in the US is complicated, of course, because we have an old law, which is HIPAA, dates back to 1996, and the High-Tech Act, which is the modern law that works on top of that, and was one of the first laws of the Obama, so it's 2009, roughly. And that's the law that introduced this security breach notification, and it goes beyond HIPAA. It applies, for example, to wearable health devices. So you have to be very careful with that. And obviously, very few people know about that, so that the FTC decided to create a reminder that they are expecting companies to file proper data breach security when they have a problem. Okay, let's move on to privacy. And privacy, well, we have the usual expectations, privacy principles that are applicable more or less everywhere in the world. You have a device that's collecting personal information. You have to tell your customers what you do, and you have to tell them why you can do that. And then you have to tell them who has access to that. I mean, it's pretty basic, but there are a number of companies that forget about this stuff. And so I want to show you a few cases in that area. This one is one of my favorite. It's a case against a TV company. And not only was it noticed by the Federal Trade Commission, but also the New Jersey State Attorney General decided to join the FTC. It's very unusual. Typically, you have the FTC doing its cases or the state doing their cases, but it's one where they joined. And in that case, not only did you buy a TV, but you also bought a connection with the internet, where the TV company was collecting viewers' information, what kind of stuff they watch, what kind of shows and so on. But also it was combining the data with data that the company itself had, because it had sold the TV and people had registered. So they had email addresses, they had profile information, income, household size, and so on. And of course, this is all that to information to third parties, but they forgot to tell the customers. So typical reaction of, in these cases, you go through your FTC visit, and the typical order, you have to delete your information, you have to get your act together, you have to implement a comprehensive data protection privacy program. And because of the circumstances, they ended up having a fine of $2.2 million. So how, I mean, I've mentioned the FTC. FTC Section 5 is one of the most typical ways that we hear about those cases, and the companies get in the typical trouble that I have mentioned. One of the recent cases just coming up 3 months ago is a case against Flow Health. It was a company that provided an app for use by women in connection with pregnancy planning and fertility tracking. And you can imagine the type of data that these women were putting in the app. But the app owner found that there was good information that they could share with very reliable companies in connection with privacy issues, Facebook, Google, and also outside analytics providers. So big scandal, violation of the FTC Act for deceptive practices. And Europeans will be happy, violation of the EU-US Privacy Shield. They managed to get that in, even though we all know that it's kind of out of the arsenal of processes that we use. So anyway, same conclusion as usual. Company is now facing a relationship with the FTC for 20 years and has to update its privacy notices, clear all the data it has collected, and it will be required to obtain affirmative consent to sharing information. Now, we talk a lot about FTC, but it's not the only federal law that we think about in terms of privacy, in addition to the healthcare laws. Remember the children. Children is governed by the Children Online Privacy Protection Act. And a number of cases are under that law. And it's very important because if you are violating the COPA law, you can be fined, which is not the case when you are violating the FTC Section 5. So here is a case, a very recent case, July 2021. CubHub is a European company, and it was providing coloring books, allegedly for adults, but it had a section for kids. And that's where you get caught by the COPA net and the requirement. And of course, that company did not know about COPA and did not know that it was required to notify parents and obtain the parental consent. So final order, 3 million civil penalty, deletion of the data, and so on. In addition to federal laws, we also have state laws that I would like to mention. In the past 2-3 years, just after the GDPR, but same time as the GDPR effective date, states started adopting consumer privacy protection laws. So right now, we have 3 that are fully in the books and ready to be applied: California, Virginia, Colorado. There are several that are very close to being adopted: Ohio, Oregon. Washington is not that close, but has been on the books for a long time. Nevada has a mini, it's not a comprehensive, it's a mini consumer privacy law. And so again, when you think about how to prepare the sale, the marketing of your device, you have to look at all these laws to make sure that you have done what is expected from you. For now, don't count on federal law. The whole US Congress is aware of that. They keep talking about it, but not for this year. So the oldest of the so-called comprehensive consumer privacy protection laws come from California. And you see I have an S at the end because actually we have 2. The first one came in 2018, and it's the one that is in effect right now. It's called the CCPA, California Consumer Privacy Act. And it is so complicated and so poorly written that it needed to have regulations. And it took 2 years to create those regulations. Now they're final, and they are pretty comprehensive. But in the meantime, the person who was the creator of the CCPA decided that it was not enough. There was not enough in the law, that the law was missing stuff. So we got CCPA version 2, which is CPRA, California Privacy Rights Act, which was adopted in November of 2020 and will become effective as of January 1st, 2023. But apply to data collected on or after January 2022. So that makes complication. And that law is written maybe a little better than the first one, but still is prompting the preparation of regulations, which are in 27 different categories. So you have to expect a lot of drafting and so on. Just to clarify and make sure, CCPA will be integrated into CPRA, meaning that CPRA is an amending law. So once CPRA is in effect, CCPA as such does not exist anymore, because you combine the old provisions of CCPA and the amendments of CPRA. But of course, that creates a lot of work for companies. So what is CCPA? CCPA, the idea was to create something that looked a little bit like the GDPR, but focusing on marketing and on the use of data for marketing purposes. And so that's why I say CCPA equals GDPR minus X, because there are a number of aspects of GDPR that are not there, because the idea was marketing, data profiling, that was not a concern unless it had to do with marketing. The obligations of the data controllers also had to be related to control of the use of data for marketing. And I say plus minus X plus Y because CCPA in many ways is even more comprehensive or more restrictive or more demanding than the GDPR. So one of the cautions I want to give you is don't think that because you have your beautiful CCPR, the GDPR privacy policy, that it can work fully with CCPA, because it doesn't. And an example of just looking at the content of the required content of a privacy notice, you need to describe what the business has collected in the preceding 12 months, which is not really the way GDPR is phrased. When you make your description, you have to make a difference between the data that the company has sold and the data the company has shared. So again, that changes the structure of your privacy notice, perhaps. Then there are very strong provisions concerning the sale of the personal data. So yes, in GDPR, someone can object to the sale of his information, but under CCPA, we have 3 versions of that. So if you have an adult, you can opt out of the sale of information. If you are a child and you are between 13 and 16, you can do things yourself, but it is opt-in. So you can decide to opt in, but not to opt out. So the collection is prohibited, but children between 13 and 16 can on their own decide, no, I want to have my information sold. And then you have a third category, which is the under 13, where the parents make the decision. And again, the decision would be to opt in to have the information collected and sold. And of course, it is so complicated that in addition, you have to have a link in your privacy policy that links to a page where all of this opt-in, opt-out has to be explained. And so you need to have a link. Let me look at most privacy policies these days of California companies, there is something that says, do not sell my information. So when you click there, that's where you have the consumer has the possibility to reply to, make those decisions. Colorado just passed a law about a month ago, will be effective January 1st, 2023. This one is much more friendly than the CCPA because it was written by real lawyers who have training and who use the same terms as GDPR, which is wonderful. You can compare the laws and not need a dictionary to figure out what we're talking about. Beyond that, we have a number of laws that are affecting IoT devices that you need to think about depending on the type of IoT situation you have and type of applications you have. The numerous laws relating to autonomous vehicles, because the autonomous vehicles collect a lot of information, including personal information. We have drone laws that have to do with people using the drones to make pictures of what's happening in the neighbor's garden or whatever, and that's also controlled by some laws. Medical devices, I've mentioned that. And beyond that, I mentioned already security laws. We have states, about maybe 20 states that have passed cybersecurity laws that would be also affecting these devices. Litigation, privacy litigation. So we've talked about what the government does, so what the FTC does, what the state AG does, but there are cases where individuals also can file cases against companies. And again, the first case I mentioned is again a medical device. personal device. That one was called an intimate device that was used, available for sale, and that again secretly collected information about what the users were, how and when and how often the users were using the device. It ended up with a class action and with a settlement of 3.75 million. So this is direct action by the users against the company. The next one, I mentioned it earlier. I said that you can find IoT in many places, and including in buildings. And so the card that you use to get in your building, your office building, your garage, the parking, and so on, is in a way an IoT device because it connects to some way of collecting information and keeping track of things. And there was a case by people living in a building saying this was abusive, because that allowed the landlord to know when you're in, when you're out, what your practices are. That one is also what we've seen happening frequently now, the device being used as the primary witness in criminal cases. And I know that Claire mentioned that. We've had the home system, the Alexa and so on, recording information, and the police seizing the device as evidence of what was happening the night of the murder. Same situation in number 2, where the wife's fitness wearable device allowed to provide information that was used to charge the husband of murder and insurance fraud. Talking about insurance fraud, the last one also, the homeowner said, "Oh my God, my house is on fire," but he had a pacemaker, and the pacemaker provided information that was contradicting what he said he was doing. I know I'm almost out of time, or already out of time. So the last one, the takeaways, well, basically, keep telling your clients that we need privacy by design, privacy and security by design and by default. That's important. Don't wait until your product is on the market or the FTC knocks at your door. Watch out for liability everywhere, in contracts, in acquisitions, in licensing agreements, in supply agreements, and make sure that you have what will help you if or when the device breaks down. Privacy, make sure that you have appropriate disclosures, make sure that you have consent when it's needed, and have a privacy program. Security, same thing, have appropriate security. And also, I mean, the favorites, my favorites, train your employees, your consultants, your service providers, your CEO, your board of directors, because they don't understand this stuff, and you will never get your money to do something useful. And perform periodic audits. So I'll stop here. Michaela, giving back the mic to you.
Thank you very much, Françoise. And I would directly hand over from Palo Alto to Australia to Bronwyn, who will speak about data transfers in and out of China and other Asian countries. So over to you.
Thanks very much, Michaela. And thanks to everyone for having me here today. Apologies for that slight delay. It is the evening here, and our office workers were just cleaning our office and with the vacuuming, and I thought I'd better just ask them to move because it was a bit noisy. So, so thank you everyone for your time today. Can you see my screen? Not as yet. No, just bear with me one moment. Can you see that one now? Great, excellent, thanks, thank you. So as Michaela mentioned, this session now is on data transfers, and we're focusing on the Asia Pacific region with China, and then as many other countries as I can get through in the time frame, but I expect that we'll probably deal with 4 today. So China, Australia, New Zealand, and Singapore, I expect. Sorry, just a slight delay while I work out how to do it. Sorry, my slide's not moving on. Oh, here we go. Great. So data transfers, as you know, are a significant focus point for us all in recent years, becoming even more so, I think, as each year passes. And there's been significant changes in the Asia Pac region over particularly the last 12 months, with a focus in China with a raft of reform there. And also in New Zealand, and then we've had a recent draft adequacy decision for South Korea as well. So all of these changes are impacting on the requirements that we're all required to follow for data transfers in those regions. As I mentioned, we'll take you through some of the Asia Pacific country requirements, and as eloquently put by Jay Davies earlier, some of this, of course, is subject to translation. I'm based in Australia, and we're an Australian and practice, and so that's the area in which we specialise. We do work with a range of associates globally, but obviously not my core regions. So in terms of China, there's the new personal information protection law that's due to come into effect on the 1st of November, so imminent, and just passed just recently. And so in terms of the landscape to date, there's already been the existing cybersecurity law, which has been regulating cross-border transfers from China. And the way in which that one worked essentially was it imposed particular requirements for critical infrastructure operators, including data localization requirements, and then requirements for security assessments and consent before sending information offshore. And also, to a lesser extent, operators of computer network servers and websites more generally, with slightly lesser restrictions there, just primarily based around consent. There's also, I guess, a myriad of different regimes in China that you need to be aware of in relation to transfers, including some sectorial regimes that apply, particularly to the financial sector, and also to the medical sector. So, for example, in relation to the financial sector, again, there's generally a focus on retaining information within China, and then the transfer can take place in certain limited situations where it's prescribed by law or regulation, or by certain institutions, the People's Bank of China, for example. And so in relation to the health information, then there's a number of different regimes that apply. And these cover aspects such as big data for health, and again, require a localization requirement, and then a security assessment before a transfer is made. And then there's also requirements for population health information and biometrics and other genetic information. So I guess you just need to view this in the context of, we're going to focus on the personal information protection law here for this session, but there are also other very specific requirements that you might need to have regard to, depending on the types of personal data that you're talking about or looking to transfer. So then the PIPL builds on those requirements under the existing cybersecurity law, and basically broadens this out. I'll perhaps just swap to the next slide. And essentially it imposes some preconditions to a transfer, and then it also imposes some very specific requirements that need to be made in order to facilitate that transfer. So if we start with the preconditions, And so before making a transfer, you need to provide notice to the individual and obtain prior express consent. And I'll touch on this and the requirement for this in a little bit more detail in a subsequent slide. You also need to perform a privacy impact assessment, or a PIIA, as those of you in Europe, I think, are more familiar with referring to them as, and go through the relevant risks and so on in relation to the transfer. There's requirements around record keeping for the transfer, and also you need to bear in mind that there are certain types of information that it simply may not be permissible to transfer, and that is particularly where there's a data localization requirement. And again, I've got a couple more examples as we go through, but for example, in relation to information to support judicial processes offshore, that sort of information cannot be transferred out. So you need to bear that in mind. So then moving through into the specific requirements. So you're now looking to transfer the information out, and what are the mechanisms that you can use to lawfully do that? And there's 4 different ways that are prescribed under the PIPL. And the first, and I should say that PIPs are really referred to as personal information processes. So basically the bucket of companies or organizations that are subject to the regime, private sector. And so the first one is what's known as a security assessment. And unfortunately, the PIPL doesn't provide any real details on what is going to be required for the security assessment, except that this is something that we can expect will be organised by the Cyberspace Administration of China, or the CAC. And the CAC is the regulator for the PIPL. And it's also the central internet regulator for China as well. Now, I've got a little asterisk there after the security assessment dot point. And the reason for that is that there are some categories of organisations that must follow this requirement. So, for example, critical infrastructure operators will need to rely on this CAC security assessment. The next one is a PI protection certification. And again, at this stage, the PIPL doesn't provide any detail regarding that certification and what's going to be required for the certification to arise. So that's a bit of a watch this space. We'll wait and see for that detail to be developed and to come out. The next one is a standardized contract. And the standardized contract is really, I think, going to be similar to what we're used to seeing in terms of the model clauses under the GDPR. And again, we're expecting some prescribed form for this, again, to be released by the CAC. So again, there's another watch this space for that detail. It is going to have to set out the rights and obligations of the parties, which is why we're expecting it to be similar in some respects to the model clauses. There's then a bucket, the last one, which is in accordance with other laws and regulations. So if there's something else that specifies that the offshore transfer can be made, so for example, in relation to those specific financial services transfers, then the PIPL has this bucket catch-all at the end that will allow that. There's also a provision in the PIPL that says that international transfers can take place where there's an international treaty or an agreement that's entered into that facilitates that. At this stage, I'm not aware of any that will fall within this category. But again, I assume that this will be similar to an adequacy type bucket here. Obviously, international treaties are their own beast, but in terms of the other agreements. It's important to remember that notwithstanding that you need to take one of these 4 mechanisms to facilitate the transfer, you also need to take necessary measures to ensure processing by the recipient still meets the standards stipulated by the PIPL. So really comparable standards to what the organisation in China is subject to under the PIPL. And the commentary at this stage doesn't seem to be clear around whether or not one of these 4 mechanisms is going to be deemed sufficient to meet that objective. But on reading, albeit the translated version, so to me it seems like it's an additional requirement. So we'll just wait and see, I think, for the further commentary and an explanation around that point as it comes out. But there's definitely some question marks there. So I've mentioned consent. The PIPL then goes on to say that if you're going to make a transfer, then you need to provide prior notice to the individual data subject who's affected and obtain their prior consent. And this is where, in my mind, it gets practically really complicated because just the process for going through this, because the notice needs to cover the name of the overseas recipient and their contact information, the purpose of processing, the processing method, the types of personal information to be transferred, and then the procedures that that individual can use to exercise their rights under the PIPL. And so it's really quite specific as to each transfer that's being made, which I can imagine might be somewhat problematic as your business practices change over time. There has been some limited commentary that suggests that consent might, the way you would interpret the law is that consent may not be required if your basis for processing is not consent. On my reading of the regime, to me, it appears like a completely separate concept. One is consents dealt with earlier on in the regime in relation to the basis for processing, and then there's a very express provision in the offshore transfer section that deals with provision of consent for offshore transfers. But I guess there is potential for some ambiguity given that a transfer is a type of processing. As I mentioned, there's those specific requirements for some PIPs. So you need to bear in mind that those other regimes will still continue, as I understand it. And so operators of critical infrastructure have those specific requirements that they will also need to be meeting under the cybersecurity law and other regimes. And when we're talking about the critical information infrastructure operators, energy, transportation, water conservancy, finance, and so on. There's also PIPs that are processing large amounts of personal information, and they also fall into that category of being required to follow that security assessment option before transferring data offshore. And interestingly, though, what constitutes a large volume of PI is another watch this space. We don't yet know what that actually means, but we're expecting guidance to come out again from the CAC to explain what that threshold actually is. Over and above that, each of the provisions around the offshore transfer are predicated by there needs to be a real need to make the transfer. And so the general provisions are, the exact wording is, of the translated version is, if a personal information processor really needs to provide personal information outside the People's Republic of China due to business needs, then it shall meet one of the following 4 conditions that we've just run through. So there needs to be a real justifiable need for making the transfer. And so that's something I guess you need to bear in mind and will perhaps be fleshed out in the requirements for the security assessment too, or the certification process. And the CAC security assessment is just there to draw your attention back to the fact that those operators of critical information infrastructure and the large volume processing of PI are required to follow that CAC security assessment option. As I mentioned, there's those other relevant requirements. We've really touched on that in reverse order this evening. So you've got the special categories that I mentioned for the financial sector and the medical sector, and then that bucket of information. So data, it's been broadened out under the data security law more recently, just to say that now any data being transferred across for judicial or enforcement assistance outside of China needs approval of competent authorities. So it used to be limited, I think, to criminal proceedings, but it's now been broadened out to all international judicial and enforcement assistance. So it shows, I guess, there's a bit of a flavour for data localisation through the various reform that's going on. So moving from China now onto Australia. So Australia is regulated primarily in the private sector by the Privacy Act, which is a Commonwealth Act, and that regulates across the board, okay, so throughout all of Australia. But it's really important to remember that the Australian Privacy Act is just one of our privacy acts, and we have many, many, many others that can apply both to private sector and to public sector. So almost every state and territory in Australia has its own Privacy Act on top of this Commonwealth one. And they also further have specific health privacy legislation in many instances, and also specific surveillance legislation. So when we're talking about the different regimes that apply, then there's very many. And there's also some further work going on here in relation to security of critical infrastructure. So similar to those categories of business that we've seen in China in the slides we just went through, and Françoise also touched on it for the US. So just bear in mind that the data storage and transfer for those types of industries is also going to be subject to further regulation in Australia. The Privacy Act does have extraterritorial scope in Australia. So there's what's called an Australian link test, which essentially means that offshore companies that first collect information that is handling information that was first collected in Australia can be subject to the Privacy Act themselves. So that's something that is sometimes lesser known about our regime here. And we have no adequacy decision, which is perhaps a topic for a whole nother day. So we're still quite stringent, but there are particular gaps in that federal law around employee records and government records, and a few others relating to journalism. So specifically moving back to cross-border transfers in Australia, the requirements are much more simple than what we've just seen for China. So the basic requirement is that you need to take such steps as are reasonable in the circumstances to ensure that the offshore recipient handles the information in a manner that's consistent with our Australian privacy principles. And there are 13 principles that are set out in the Privacy Act. That just take you through in basic form as to how you're going to handle information through its life cycle in the organisation. The problem with following that 8.1 requirement is that the Australian entity making the transfer retains deemed liability for the acts and practices of the offshore organisation. So that's quite unpalatable for an Australian organisation making the transfer. The Act provides some exceptions to 8.1. So it says you don't have to take those reasonable steps if you meet one or more exceptions. And the reason why we always recommend to clients that you try and fall within one of those exceptions is that if you do, you also avoid that deemed liability. Okay, so it's something quite important to bear in mind. So when we're talking about these exceptions, this is the only slide where I've set out the law on the page, so forgive me, but I think it's useful to see them. The most useful exception is usually where you're dealing with an entity that's subject to a comparable regime, and where the Australian individual whose information is being transferred has an ability to take action to enforce their rights in that jurisdiction. So they need to have standing. So from a, say, GDPR perspective, generally the view is that GDPR will satisfy this requirement. And I guess you can start to trace that through to the various other jurisdictions that have adequacy decisions and comparable regimes, but does need to be carefully looked at to make sure it meets that requirement. You can also make that transfer and fall within the exception where you get the individual's consent, but again, that's quite commercially unpalatable because you actually have to tell the individual in very clear terms that the disclosure is being made and the information might not be handled in accordance with the law. So generally, you try and look to that comparable jurisdiction. And there's a raft of other exceptions that less commonly apply. So I won't spend the time going through them in today's session. So I guess the crux of the matter for Australia is you either need to meet that 8.1 requirement, which means that you're most likely going to need a contract in place that requires the recipient to handle the information in accordance with the Australian privacy principles, or you need to make sure you fall into one of those 8.2 exceptions. Okay, and again, that can be checking the comparable law in most instances. Checking that the recipient, is subject to the comparable law. And that's the preferable outcome because you avoid that deemed liability. So I'm conscious I've only got a short time left, but moving to New Zealand now. So New Zealand's just been subject to a raft of reform, a brand new Privacy Act, known as the Privacy Act 2020. And that's brought its regime very much in line, I think, with GDPR, but also very similar drafting and wording in many instances to the Australian regime. The New Zealand regime does have an adequacy decision. It does not have those same gaps that the Australian regime has around employee records and government data and so on. So the cross-border transfer requirements under the New Zealand regime are relatively similar to what we see both under Australia and under the GDPR. It's a combination of the two. The Privacy Commissioner, one of the grounds that can be relied on to facilitate that transfer is a use of the model clauses, and they've just more recently been released by the New Zealand Privacy Commissioner. However, the New Zealand Privacy Commissioner has interestingly suggested that these would be more suitable for small to medium business enterprises, and that larger businesses may wish to develop their own model clauses to use. In terms of the New Zealand privacy law, it does also have an extraterritorial application, which is worth understanding, because what it essentially means is that it can apply to overseas entities where they're in relation to personal information that has been collected by the entity or held by the entity, where the entity carries on business in New Zealand. And carrying on business in New Zealand is not defined by the Act, and it's really given quite a broad meaning, and it has tax considerations and so on. So won't go into it in detail, but it doesn't mean that you have to have a commercial operation in New Zealand or a place of business, or be receiving monetary payment for the supply of goods or services, nor do you have to intend to make a profit from conducting business in New Zealand. So, it can be possible to have activities involving your business in New Zealand without meeting any of those criteria and still be deemed to be carrying on business. Okay, so potentially quite broad. Once you're subject to the Act, as I said, when you're making those transfers of information from New Zealand out to another jurisdiction, then you need to be complying with that Act. And principally, the offshore transfer requirements are set out in Information Privacy Principle 12. So like the Australian Act, the New Zealand Act sets out 13 privacy principles, slightly different though. And it's Privacy Principle 12 that regulates this. And basically you can make the transfer where the recipient is subject to the Privacy Act themselves, the New Zealand Privacy Act themselves, and you need to have reasonable grounds for making that assessment, or where they're subject to a comparable regime. And the Commissioner has noted that you would need to make sure that you are conducting careful checks and undertaking sufficient due diligence, similar to the Australian requirement. You also need to, another ground is that the third party agrees to adequately protect the information. And so the best way to do that is through those through contractual provisions, and you can use those model clauses for that purpose. There's also the option for particular jurisdictions to be prescribed, but we haven't seen any of those as yet. And the remaining ground is, again, consent of the individual. Okay. It's interesting to note that there's a concept both under the Australian regime and the New Zealand regime that a disclosure to a cloud provider offshore may not necessarily, I should say transfer to a cloud provider offshore may not necessarily be subject to these requirements. And that's because if there's sufficient controls in place and that provider is not actually engaging in any use of the data themselves, then they can be deemed to essentially be holding it on behalf of the Australian or New Zealand entity and not actually making a collection themselves. So it's not actually a disclosure, as the term is used in our regimes here. So also bear that in mind, depending on the way your contractual relationships are set up. If the contractual relationship is sufficiently tight and the use by the offshore recipient is extremely limited and subject to the control of the Australian or New Zealand entity, then sometimes these requirements don't kick in, but that needs to be carefully considered. I think we've covered all of that slide already. Sorry, only 4 minutes to go. So up to Singapore, there's a race through, and there's so many more jurisdictions we could cover, but I think this is it for today. So cross-border transfers for Singapore. Conversely, Singapore's business practices are not to encourage data localization. So to what we saw earlier, so the Personal Data Protection Act, or PDPA, is set up to make transfers a lot simpler. There's no express extraterritorial scope for the Singapore Act. So obviously where you're collecting information within Singapore and handling it within Singapore, you're subject. If you transfer that out to a data intermediary, or I think it even extends to a member of your corporate group, perhaps, where you've still got retained control over the information, even though it's outside of Singapore, then as the organisation bound by the Singapore Act, you are still responsible for it and must make sure that you handle it in accordance with the Act. Once it goes out to a third party and that control is lost, then and that's deemed to be a transfer limitation obligation as kicks in as the commissioner refers to it. And then that's the point where you need to take appropriate steps to ensure that that recipient is bound by legally enforceable obligations. And the commissioner used or specified certifications compared to the PDPA, but the exact wording of the provision is that an organisation shall not transfer any personal data to a country or a territory outside Singapore, except in accordance with requirements prescribed under this Act to ensure that the organisations provide a standard of protection to personal data so transferred that is comparable to the protection under this Act. So again, it's really about that comparable standard. And so in terms of what constitutes a legally enforceable obligation to have a comparable standard, that can be a law, a privacy law in the country where the recipient's located that requires them to meet that same or higher standard. It can be achieved through contractual clauses and perhaps even through the binding corporate rules concept that we're all familiar with. And yeah, so the overarching concept is just to make sure that that comparable standard's there. And as I said, there's a bit of there's a need to make sure you understand whether you're making an actual transfer subject to this requirement, or whether you're passing it to, say, a data intermediary, which is more akin to a processor under GDPR. Okay. And so in the interests of all of the different requirements, I hadn't produced a summary page for them all because the text would be rather small for one slide. So that's it from me for a brief run through.
Thank you very much, Bronwyn. This was like very, very interesting, and you finished right in time.
Yeah, I tried. So sorry, I think there's so much more detail in each of those regimes and so many more interesting jurisdictions that we could have covered, but time did not permit. So.
Of course.
Yeah.
So thank you very much to you, and thank you very much to all the speakers of this session for the very interesting talks and presentations. Thank you also to the attendees for your attention. The next session will start in an hour at 1:45 p.m. on Digital Services Act and Digital Markets Act. And you can now disconnect until 1:45 and then reconnect with the same link. Thank you. Bye.
Thank you.